appeal, Isle of Wight Council and Platt.
Mr. Chamberlain.
My Lords, my Lady, I appear with Ms Emily Mackenzie for the appellant Isle of Wight Council. Mr Clive Sheldon, Queen's Counsel, and Mr Paul Greatorex appear for the respondent, Mr Platt. Mr James Eadie, Queen's Counsel, and Mr Louis Mabley appear for the Secretary of State intervening. Before I say anything else, I've been asked by Mr Sheldon to draw the Court's attention to the fact that an order was made below. You have a copy of that order in the core volume at MS page 108.
Yes.
And it requires that no publication or report of these proceedings shall refer to or identify any child by name. Mr Sheldon asks that that order be continued by this court, and we have no objection to that.
Well, it would have been helpful to have had notice of that, so we could have had an order typed up ahead. But nonetheless, I think, given the order was made below and there's no objection, I think we will make that order. That's all right, isn't it? Agree? Yes. Very well. Well, in that case, just think for the benefit of everyone in court, nobody should announce or state the name of the what it the family involved or the child?
Just the child.
Of the child, the subject of these proceedings, or his or her address, or give any information which could lead to his or her identity or his or her address being identified. An order will be drawn up to that effect, so if anybody wants to see it, they can see it.
Is this really going to do any good at all, as everybody knows the name of the parent and everybody knows the council?
My lady, the name of the child has been kept out of the public record.
That's not the question you're being asked.
No, but in a sense, they know the name of the father and they know the name of the authority, but no one has mentioned the name of the child, and so it has that effect that if she was to, at some stage Google her name, she wouldn't find it there, along with all the other press around this particular matter.
There's no problem about using the name of the respondent.
No problem with that. I think it would be far too late to ask for that.
I say, yeah.
Well then, I think we'll make the order for the moment, but after the short adjournment, we'd like to be persuaded that it is really sensible to make it, given that the identity of the council is known, therefore where the child resides is known, and the child's father's name is known.
What about the school? The identity of the school, is that known?
The identity of the school is known from some of the press.
Record,
that is in the public record. But
what I suggest we do, rather
we have the surname, we have the school,
and we have the local authority. I suggest that you think about this. We'll make the order for the moment for safety's sake, but it does seem to me, in light of the questions you've been asked and the answers you've given, you may want to consider whether you can persuade us really that there's any point.
My lord.
Good.
My Lords, my Lady, with the Court's permission, I'd like to make submissions under 6 heads.
Yes,
First,
of course. And just for the record, we should say that we've all read the judgment below, and we've read your helpful three respective written cases.
I'm grateful. The first head, and very briefly, the facts and issues. Second, the statutes enacted between 1870 and 1944, and the case law interpreting them. Third, the case law interpreting the 1944 Act. Fourth, the 1996 Act. Fifth, what we referred to in our case as the alternative case. And finally, our answer to the points raised by Mr. Sheldon in his case against us.
I think, subject to any of my colleagues feeling otherwise, you can certainly take the first 4 fairly quickly.
Yes.
Really, the issue is embodied largely in the 6th point, is what does this provision mean?
Yes.
3.
I agree.
Good.
My Lords, my Lady, appeal arises from the from proceedings before the Isle of Wight Magistrates Court. Those proceedings were brought by the Appellant Council because the respondent, having sought and been refused permission to take his daughter out of school for a holiday, did so anyway. She missed school for 7 consecutive school days between the 13th and the 21st of April 2015.
Thank you.
The council issued a penalty notice for £60, as the head teacher had warned in advance they would. The respondent failed to pay and was prosecuted. And the reasons of the Magistrates Court for upholding the submission of no case to answer are set out in the core volume MS 132
Yes.
at the end of the case stated from paragraphs 27 to 29.
Thank you.
Essentially, the magistrates thought that the question, it's 132 is the form on which the reasons are recorded. The case stated is at
Page is it?
129.
Yep. Yep.
Essentially, the magistrates thought that the relevant question was whether the child was a regular attender, and that this had to be considered taking into account attendance over a wider period than that specified in the information. The child's attendance was 95% before the holiday and 90.3% afterwards, and the documents supplied on refusal of leave had specified that 90 to 95% attendance was satisfactory. 90% attendance, at the risk of stating the obvious, is the equivalent to half a day off per week. The issue in this court concerns the meaning of attend regularly in the Education Act 1996. Now, that phrase or its cognate appear in 2 places in the 1996 Act. It appears first in section 7, which you have in Authorities Bundle 1, tab 12, MS 324, which imposes on every parent a duty to cause his or her child to receive education of a particular sort, that is, efficient, full-time education, suitable A, to his age, ability or aptitude, and B, to any special educational needs he may have. The duty can be discharged either by regular attendance at school or otherwise. The concept of regular attendance is picked up in section 4441, which you have at MS 337, and that provision creates an offence committed by the parent of a child who is a registered pupil at a school and who fails to attend regularly at the school. The terms of section 4441 reflect those of section 39 of the Education Act 1944, which is why, as both parties agree, the legislative history is relevant. Now, the question certified by the Divisional Court concerns what the magistrates should do when faced with an information alleging failure to attend regularly during a specified period. Is the child's attendance outside the specified period relevant to the question whether the offence has been committed? That question, in turn, depends on the construction of the words attend regularly. The Divisional Court appeared to think that those words mean something like attend reasonably frequently, and the respondent agrees and adopts that construction. On our primary submission, we and the Secretary of State say it means attend at all times when attendance is required by the school, so that the offence is committed by any failure to attend during those times. And we say that the legislative history and policy of the 1944 Act support this.
Don't you really say it means attends in accordance with the rules?
Well, that is the other way that we've put it, as your ladyship will have seen from our case.
Which means at all times when required so to do and not authorised.
Exactly. And the reason that we put it in that way, my lady, is to pick up what the root of the word regularly is.
Yep.
But we do say that it means attend at all times when required, or in accordance with the rules, however you want to put it.
The root of the word regularly appears to be, according to the shorter Oxford English Dictionary of 1965, which was the nearest I could get to 1944, appears to be, as my lady, you were suggesting, in accordance with the rules of an order, a religious order, actually.
Yes, and you'll have seen that the one...
One root, anyway. I mean, it's certainly got lots of other meanings, including the one which the respondents put on it.
Yes, exactly. And
But that seems to be the earliest route, but maybe you've got better information.
well, you'll have seen from our case that we put in the OED, the Oxford English Dictionary from 1933. And the reason we put that one in is that the 1933 edition is the one immediately prior to the 1944 Act.
One
so
that
that's
I was looking at, yeah.
That's what it would have been understood as, and I'll come to that in due course. But essentially, one does see that precise meaning in the OED, but when one looks at the first two meanings of regularly in the 1933 OED, they are consistent, we would respectfully submit, with our construction of regularly. And in fact, exactly the same definitions appear in the 1989 edition of the OED. I can give you, if you want, the references to those at this stage, but I was going to come to it slightly later. It's at Authorities Bundle 3, tab 69, MS 1074. And the two definitions given of regularly there are one, at the proper times, at fixed times or intervals, without interruption or of recurrence, constantly, and invariably in all cases. So those are the two definitions of the word regularly. I'll come to that in a moment.
It can be said with some force that words like regularly can have all sorts of different meanings in different contexts. And looking at dictionaries and looking at other cases is really pretty unuseful because we all know it can mean all sorts of different things. The question is, what's it mean here? Doesn't it?
Again, we agree, my lord, and that's why we do have to look at the legislative context and the legislative history to see whether that meaning, which I've just given you from the 1933 OED, is indeed the meaning that was intended here, and we say, yes, it was. Now, on our alternative submission, even if attendance with a singular or perhaps occasional absence could still be characterised as regular, that word must be construed strictly. And on a proper construction, absence for 7 consecutive school days was not, we say, on any view, regular. There's an issue about whether we are entitled to raise that alternative case, and I'll come to that later. Can I move then quickly to my second head, the statutes enacted between 1870 and 1944 and the case law interpreting them? There are, on this aspect of our case, 5 points. First, between 1870 and 1944, there was a statutory power and then a duty to make bylaws. The bylaws required parents, subject to certain specified exceptions, to cause their children to attend school and also set the times during which they were to attend. The bylaws were originally made by school boards and then by local education authorities when those authorities were set up in 1902. Section 74 of the 1870 Act, it's the Elementary Education Act 1870, is in tab 1 of the first authorities bundle at MS 278. And if I could just ask your lordships and your ladyship to look at that. One can see there, every school board may from time to time, with the approval of the Education Department, make bylaws for all or any of the following purposes. And one was requiring the parents of children of such age, not less than 5 years, nor more than 13 years, as may be fixed by the bylaws, to cause such children, unless there is some reasonable excuse, to attend school. And two was determining the time during which children are so to attend school, and then provision is made for religious observance. And one can see 4 imposing penalties for the breach of any bylaws, and so on. So that was the original enabling power under which the bylaws were made. Now, we have set out in our case, our printed case at paragraphs 13 to 16, some examples of bylaws which we've been able to obtain from the London Gazette. And at 14, we have given, as an example, I do it from the printed case if I may, but you can see the original of the bylaw in tab 56, which is in Authorities Bundle 3. Perhaps we just go to the original, actually. It's MS page 935. And these are bylaws for the parish of Gillingham. And one can see there what is said is that at point Article 2 of the bylaws, or Bylaw 2, the parent of every child of not less than 5 nor more than 13 years of age shall cause such child to attend school unless there be a reasonable excuse for non-attendance. The reasonable excuses are then specified, or let me put it this way, there are specified 3 excuses which shall constitute reasonable excuses, not exhaustively specified. And then 4, time of attendance, the time during which every child shall attend school shall be the whole time for which the school selected shall be open for the instruction of children of similar age, including the day fixed by Her Majesty's Inspector for his annual visit. And then the penalty is specified as not exceeding 5 shillings for each offence. And we've pointed out at paragraph 15 of our case that the bylaws for Maidstone, Preston, Holyhead, Trimley, which are all set out in the Authorities Bundle, were in the same terms, materially. The bylaws for Chelmsford, as we pointed out, were similar, but also made specific provision that all breaches of these bylaws by a parent in one and the same week be deemed one offence. So there was clearly an intention there that the offence could be committed more than once in the same week. We've also set out at paragraph 16 the bylaws for Hanslope, made on the 12th of May 1873, and they are framed slightly differently. I'm not going to read them out, but you can see them set out at paragraph 16 of our case. And essentially, the bylaws in Hanslope provided for children of a certain age to attend less than full time, and the precise number of days in each quarter that they had to attend depended on whether they were boys or girls, and depended on the seasons. So presumably that was because older boys were expected to help with agricultural work at certain times of the year. Meanwhile, in section 4 of the 1876 Act, which you have in tab 2 of Authorities Bundle 1, there was a duty on parents to cause their children to receive efficient elementary instruction in reading, writing and arithmetic. And you see that, say, tab 2, section 4, MS page 280. And that is the precursor of the duty which eventually finds its way into section 7 of the 1996 Act. But you can see that at this point, the duty was framed in terms of simply requiring each parent to cause his child to receive efficient elementary instruction in reading, writing and arithmetic. Now, at the same time, in section 11 of the 1876 Act, there was provision empowering a court of summary jurisdiction to make an order where a parent habitually and without reasonable excuse neglects to provide efficient elementary instruction for his child. So the trigger here was habitual and without reasonable excuse neglect to provide efficient elementary instruction for the child. And the effect of that order was to require the child to attend a specified school, quote, every time that the school is open or in such other regular manner as is specified in the order. Now, Lords, my lady, the respondent relies on that at paragraph 31 of his case as showing that at that time Parliament understood the word regular could mean something different from every time the school is open. In fact, Lords, my lady, it does not show that. What it shows is that because some children were at this time not required to attend school full-time, the Act had to cater for the possibility that an attendance order might require less than full-time attendance. That would have been necessary in, for example, Hanslope. If an attendance order had been made there, it would no doubt have specified attendance at the times set out in the bylaw. The obligation imposed by the order would then have been to ensure attendance in such regular manner as was specified in the order. So we say there is nothing in that use of the word regular to suggest that the obligation would have been complied with by anything less than complete adherence to the times specified in the order. In other words, all it really shows is that you can have regular full-time attendance or regular part-time attendance. If I'm required to attend every Tuesday at 3 o'clock, then I attend regularly by attending every Tuesday at 3 o'clock. And if I miss one, I have not attended regularly every Tuesday at 3 o'clock. The third point that we draw from the history is that the case law arising from prosecutions under the bylaws indicates that the obligations imposed by them were regarded as strict, and in particular that even a single failure to attend at the times required by the school constituted the offence. So in Murphy's case, which you have at tab 17, MS 418, sorry, it's not 17, it is 24, tab 24, page 418. Lord Coburn said that the threshold for the offence under the bylaws was different from the threshold for the school attendance order. And here's what he said. The offence under the bylaws, this is middle of 418. The offence under the bylaws and the offence under the statute are two essentially distinct and separate things. The offence under the bylaws is that of neglecting to send children to school to constitute which an occasional omission might suffice, while that which is dealt with under the 11th section of the statute is not that of occasionally omitting to send the child to school, but that of habitually doing so without reasonable excuse, and the two offences are dealt with very differently indeed. In the one case, the parent is simply liable to a pecuniary penalty, that's for breach of the bylaw. In the other, the magistrate has the power, having made an order which it is incumbent on the parent to obey, upon his disobedience of that order, not only to inflict the penalty which may be imposed under the bylaw, but in fact to deprive the father of the right of parental control which the law otherwise gives him, and to dispose of the child in the manner pointed out by the statute, namely by sending it to some industrial school. So those were the two routes identified there by Lord Coburn. Now, subsequent case law, which we summarise at paragraphs 18 and 24 of our case, made clear that absence for even a single day, or indeed half a day for that matter, would constitute the offence. And you see that in, for example, the case of Marshall and Graham, which is in Authorities Bundle 1, tab 26, MS 440.
Yep.
And that concerned two linked cases, and they were all about whether Ascension Day was a day set aside for religious observance in the Church of England. But in one of the two linked cases, the child had actually only been absent for half a day to attend a religious service. And although the ultimate holding in the case was that Ascension Day was a day set aside for religious observance, and therefore the defence was made out, the case proceeded on the common understanding of everybody, both sides and the court, that had it not been, the offence would have been committed even by the absence for half a day. And then we've set out in our case the other authorities which show that a single day's absence would suffice. They are Hares and Curtin, which is in tab 28. And there the allegation which you see on MS page 459 was of failure to attend on a particular day, the 6th of July 1911. And the justice is convicted, and the Divisional Court upheld the conviction. Similarly, in Bunt and Kent, which is tab 28, MS 462, the allegation, as can be seen from 463, was again of failure to attend on a particular day. And again, in this case, the magistrates acquitted, but the Divisional Court allowed the local education authorities appeal. And then finally, there is the case of Osborne and Martin, quite a tough case, your lordships, your ladyship might think. Authorities Bundle 1, tab 29, MS 472. Yep. And there the information alleged a failure to attend on one particular day when the child was having a piano lesson. And we draw attention to what was said in that case by Mr. Justice Salter on page 473, MS 473. It's a very short one-paragraph judgment. I agree, he said, a parent is not obliged to avail himself of the free education provided by the state if he prefers to provide privately for his child's education. But if he does avail himself of it, he must take it as a whole. So that was the view taken under the previous legislation. The fourth point is that legislation has progressively increased the age at which school attendance was compulsory and progressively narrowed the exceptions permitting some children to attend school part-time whilst also working. So, in the Education Act 1918, the compulsory school age was increased to 14, see section 8, that's Authorities Bundle 1, tab 4, MS 288.
Yep.
LEAs were also empowered to require attendance up to 15, up to the age of 15, either generally or for children not employed in specific occupations and subject to a power to grant exemptions. And at the same time, young persons between the ages of 14 and 18 were required subject again to certain exceptions, to attend continuation schools for 320 hours in each year, distributed as regards times and seasons as may best suit the circumstances of each locality. You have that on MS page 290. Now, we say that's relevant because it provides an illustration of the statutory formula used when making education compulsory, but on a part-time basis.
Right.
Lords, my lady, fifth is that by the time of the White Paper that led to the 1944 Act, and I hope that you have loose in front of you a copy of the White Paper.
We do.
The wrong document was inserted in the index where that
Yep, we have
paper
that.
was supposed
It's
to
the
go.
one headed secret.
It is. We don't quite know why it's headed secret. That's what was on the library copy that we were able to get our hands on. It wasn't secret. It was a white paper, and it was in fact published. But one can see from that white paper that the intention behind, that led to the 1944 Act, was to move from a patchy system that still permitted some children to attend part-time to one in which schooling was to be full-time from the age of 5 to the age of 15 and up to 16 where possible. Now, if one looks at part 2 of the white paper, which is entitled Full-Time Schooling, on page 3, it noted that the reference to elementary instruction in reading, writing and arithmetic was an anachronism. See that at paragraph 11.
Yeah.
And it proposed replacing it with a duty to cause one's child to receive efficient full-time education suitable to his age, ability and aptitude. And one sees that at paragraph 25 on page 6.
Right.
Now, that duty was in due course enacted in the 1944 Act, and you have that in Authorities Bundle 1, tab 6, MS 301.
Yep.
And you have the duty to cause one's child to receive efficient full-time education suitable to his age, ability and aptitude. And then the words are added either by regular attendance at school or otherwise.
Yep.
The offence, which is the predecessor of the one that we're dealing with today, was in section 39, and it was in materially similar terms. And that's Authorities Bundle 1, tab 6, MS 303. And it was committed by the parent of a child registered at a school who fails to attend regularly at the school. Now, we make a couple of points about that. One of them I've already made by reference to the OED. I'll just show you the OED in a minute. But the first point we make is that what is required there is a failure to attend regularly, not a regular failure to attend. That's clear when you look at 39 in the context of 36, because the concept, the duty in section 36 is to cause one's child to receive efficient full-time education by regular attendance at school or otherwise. So regular qualifies attend, not failure.
Yep.
We have also, as I've said, put in the 1933 edition of the OED. You have that in Authorities Bundle 3, as I said, tab 69, MS 1074. Now, under section 40, which you have at MS 304,
Yep.
there was a penalty, and the penalty, as you can see, depended on whether it was the first, second or third conviction. £1 for the first offence, 5 for the second, and £10 and or imprisonment for the third. And we say again that's consistent with an offence that was intended to be interpreted strictly. Now, the respondent's case must be that in enacting the 1944 Act, whose main aim it was to require full-time education for all children between the ages of 5 and 15, in circumstances where less than full-time education had previously been required for some of them, Parliament also intended to dilute the strictness of the obligation to secure attendance that had previously been imposed under the bylaws. And we say that, with respect to our learned friends, there is not a trace of any such intention to be found in any of the materials before Parliament when it passed the 1944 Act. And that brings me to my third head, which is the case law interpreting the 1944 Act. And the first, I'm not going to go through all of the case law, which is mentioned in our case, but the first important case is the case of Hinchley and Rankin. That is in Authorities Bundle 2, tab 35, page 577, MS 577. And if one just looks at the head note on 577 to 578, the register showed the child present 27 times and absent 29 times in a period of about 6 weeks. Yeah. But the evidence was that the register closed at 9:45 a.m. and a child who attended after that time would be marked absent. So the recorder said there was no evidence of non-attendance other than non-attendance before 9:45 a.m. And that was not enough, he said, to constitute the offence. If one looks at 580, the real point for decision in the case was whether the recorder's construction of the words fails to attend regularly was correct. And counsel, it is said, counsel for the prosecutor submitted with force that regular attendance for the purpose of receiving efficient full-time education must be regular attendance for the times prescribed by the body charged with the power to determine the times of each session. Yes. And then at 581, Lord Parker accepts that argument. He says, since the Act provides for full-time education and requires regular attendance for that purpose, it must be regular attendance for the times prescribed by the person upon whom the duty to provide the education is laid. Looked at in that way, even if this boy had regularly arrived a minute or two late, there would be a failure to attend regularly within the meaning of the Act. Now, of course, it is true, and as is pointed out by my learned friends, that the premise, Lord Parker's premise, was that the boy had regularly arrived late. But those were, after all, the assumed facts. And in any event, we say the reasoning supports our construction for this reason, or these reasons. First, it shows the significance of the duty to cause one's child to receive efficient full-time education. If that phrase is relevant to the question whether regularly arriving 1 minute late constitutes the offence, it must presumably also be relevant to the question whether more than a single absence is required to constitute the offence. It's a short point, but it simply shows the link between Section 36, as it was, and Section 39.
Lord Parker's approach would give the meaning of the word regularly both meanings, both the meaning you argue for and the meaning your opponent argues for, at the same time.
Well,
wouldn't it? He'd say it means, first you look at what the rules say, and then you look at whether the rules have been usually complied with.
Well,
one view, that's
when one looks at what he actually says the word meant and how he got there, he gets there by looking back to Section 36 and asking what regularly must mean in that context. In that context, he says it must mean at the times specified by the school. He does slip in an extra regularly in the next sentence, but we do say that's because those were the facts of the case. So he wasn't asking himself the question, which we have to ask in this case, which is how many times do you have to fail to attend for there to be a failure of to attend regularly.
Say the first sentence of that paragraph is the ratio, and the second sentence is applying the ratio to the facts of the
Yes,
case.
exactly.
That's okay.
That is
Thank
what
you.
I'm saying. And the second thing it shows, and the second thing that we can draw from the case, is that the respondent's interpretation would lead to a very odd result, because arriving 1 or 2 minutes late for 29 sessions constitutes the offence, according to Lord Parker, yet failing to attend at all for 14 sessions does not, or may not, depending on the view taken by the magistrates.
I suppose
That's
what he may have been saying, the other view, is that if you arrive a couple of minutes late on 2 occasions, that is in practice de minimis. Yeah. The fact it happened frequently, even a couple of minutes late, would mount up to be more than de minimis taken together.
Possibly, and if he were saying that, then it would be he would be supporting our alternative construction,
I understand.
which I come to at the end of my submissions.
Yeah.
The second case is the case of Crump and Gilmore,
Yep.
and that is in tab 36 at 583.
Thank you.
There the question was whether the offence was committed when the parents knew nothing of the child's absence. And the answer that you see at 586 is yes. The offence was absolute and it was unnecessary to show knowledge on the part of the parents. He goes on at the bottom of 586 to say the real and only question here is whether the 12 occasions out of a possible 114 when this little girl was not attending school and had no reasonable excuse for not attending amount to a failure to attend regularly. In my judgment, they do, and what is more important, I read the case stated as showing that the justices were of the same conclusion. Now, what's said against us here is that this passage shows that there was at least a question whether 12 absences amounted to a failure to attend regularly, and that this was a question for the magistrates. We say, at best, it evidences an assumption to that effect, but because Lord Parker's view coincided with that of the magistrates, there was no need for him to consider whether it would have been open to them to conclude that 12 absences out of 114 was regular attendance. So there is actually nothing in this decision directly dealing with the meaning of regular attendance. Now, what that means in our submission is that it cannot be said that this decision contains what's been referred to as an authoritative judicial interpretation of the phrase regular attendance of the kind that would trigger the Barras principle. And that's the principle which is discussed by Lord Hodge in the case of N and Lewisham, which you have in Authorities Bundle 2.
Pretty familiar with the Barras.
Yes. Tab 48, MS 814, paragraph 53.
Thank you for the reference.
I'm going to come back to that case because one of the features of the case, of course, is if one just looks at the number of absences in that case, 12 out of 114, that's an absence for 6 days out of 114 in the specified period. And there is, particularly when we come to our alternative submission, something a little odd about a law which can be interpreted so as to give rise to the offence in those circumstances, but not these. The fourth head then is the 1996 Act and the case law interpreting it, and my Lord asked me to get to this head quickly. I hope I've got to it quickly enough. The 1944 Act was replaced in 1993 and then again in 1996. But there are no material differences between the 1993 and 1996 Act, so I don't propose to dwell on the former.
Thank you.
The one thing I do want just to show you by reference to the 1993 Act is one commentary on that, For your note, the relevant part of the 1993 Act is Part 4, entitled School Attendance, and that's in Authorities Bundle 1, Tab 11, MS 316 and following. So far as we're aware, there was only one commentary on the 1993 Act. It wasn't wasn't in force for very long, but that commentary is that of Dr. Neville Harris, who is now Professor of Law at Manchester and editor of the Education Law Reports. And he said this about the phrase regular attendance in section 192. And it said tab 72, Authorities Bundle, tab 72, page 1081. So if one just looks at that, it's the note a third of the way down the page, regular attendance. This is not defined. It is generally taken to mean attendance at the times prescribed by the governing body under their power in section 21(2) of the Education Act 1986, not including times of arrival after the register has closed, see Hinchley and Rankin.
Yep.
And if you turn on in that same tab to 1089, you'll see that there is a reference back to that same view in the note to section 199, which is the section creating the offence that is now contained in section 444. Now, that is not, of course, itself an authoritative judicial interpretation, but insofar as it's said against us that at the time of the passage of the 1996 Act, Parliament would have understood the question of regular attendance to be a question of fact and degree, it helps in our respectful submission to negative that suggestion. And it's relevant to note that precisely the same understanding of regular attendance appears from commentaries on the 1996 Act, and you have in particular Vera McEwen's commentary in Authorities Bundle 3, tab 73, MS 1101. She says regular attendance is not defined, but is taken to mean that the child must be present for the school sessions as identified by the governing body, and as such, strict adherence to the requirements regarding registration of attendance is important. And you also have at tab 76, MS 1144, Richard McManus QC, who says this: a child fails to attend regularly if he fails to attend at the times prescribed by the LA.
Which page was that, say? Sorry.
That's 1144.
Thank you.
Can I turn then to the provisions of the 1996 Act? The first provision is Section 7, which mirrors Section 36 of the 1944 Act. And it imposes the duty on the parent of every child of compulsory school age to cause him to receive efficient full-time education suitable to his age, ability and aptitude, and to any special educational needs he may have, either by regular attendance at school or otherwise. Now, just pausing there for a moment, the respondent in his case says that this duty is akin to the target duties placed on the Secretary of State and local authorities in sections 10 and 13 of the Act. And you have those in Authorities Bundle 3, tab 78 at MS 1152 to 3. I'll just say a word about that. The duty in section 10 is a duty on the Secretary of State to promote the education of the people of England and Wales. Yeah. Now that is what you would call a target duty. But we don't accept that the duty in Section 7 is in any way comparable to that. The reason why the duty on the Secretary of State can be regarded as a target duty is that it's framed in very general terms. The words are simply insufficiently precise to be enforceable directly. A duty to cause one's child to receive efficient full-time education by regular attendance at school or otherwise, on the other hand, is very specific, whatever the true meaning of regular, whether it's the one that the respondent attaches to that word or our construction. Now, the Secretary of State is right, we say, to characterise the offence in Section 4441 as an offence which operates as an enforcement mechanism for the duty in Section 7. Now, it's true...
Am I right in thinking, Mr Chamberlain, that there is another offence which is directed at those parents who don't register their child in a state school, but choose to educate their child in another way, or not, as the case may be? Is there not another offence that deals with that?
There is. Well, there's Section 437, which I'm going to come to in a moment, which deals with education attendance orders.
No, I don't mean that.
Ah.
Well, it may be that the attendance order is the route to the next.
It is, yes, I think, my
yes.
lady, yes. And so I'm going to come to that in a moment.
But the only reason I'm asking is that people may be thinking, well, Section 7 allows you to choose how you educate your children. It doesn't allow you not to educate them, but it allows you to choose
exactly.
which school, which sort of school, or to home educate children,
yes,
and the like. And if there's an enforcement mechanism for those who choose to register their children, there must be an enforcement mechanism for those who choose something else.
There is, and it's 437. And the way we say, the structure of it and the way we say it works is this. It goes back to that paragraph from Mr. Justice Salter, which I showed you before. If you choose to take the route of sending your child to a school and discharge your Section 7 duty by that route, then you have to attend, the child has to attend at all times when required. If you choose not to, well, then it's up to you to ensure that you provide efficient full-time education. If you don't provide efficient full-time education, then the route under Section 437 is open. And at that point, an order can be made by a magistrate's court requiring you to cause the child to become registered as a pupil at a school named in the order. And that would be if, for example, the local authority has come to inspect the education that you are privately providing for the child, has come to the view that it is not efficient full-time education, not adequate, yes, and therefore the child has to go to school. We do say, of course, it's right to say, as the respondent has, that the words full-time in Section 7 are not defined, but we would say they don't need to be. Their meaning is plain. And as Lord Parker's judgment in Hinchley and Rankin shows, or the ratio of it at least shows, that meaning casts significant light on what regular attendance means. Now, can I ask you to look now at Section 444 itself? It's MS page 337, Authorities Bundle 1, tab 12. Yep. Subsection 1 creates the offence at issue here. It is, to use Lord Parker's terminology in Crump and Gilmore, an absolute offence. It does not require knowledge on the part of the parent.
Yep.
Subsection 1, capital A, creates a more serious offence where the parent does know that the child is failing to attend regularly at the school and fails to cause him to do so. But subsection 1, capital B, provides a defence if the parent can prove that at the time of the absence the child was prevented from attending by reason of sickness or unavoidable cause. Subsection 2A provides that defence generally, but subsection 1B provides a separate defence of reasonable justification to the 1 capital A offence. So you'll recall that there was, I mentioned tangentially earlier, that the statute had always set out a number of excuses which were to count as reasonable excuses. But there was some discussion in the case law about whether those were exhaustive or not. The answer was that under the previous legislation, they were not exhaustive, but under the 1944 Act, they were to be treated as exhaustive. So when the new, more serious offence under 1A was introduced, there was a separate, specific defence under 1B of reasonable justification. And that could be anything that the magistrates properly regard as a reasonable justification. Subsection 2A applies to the main offence as well, and that provides that there's a defence if the parent can prove that at the time of the absence, the child was prevented from attending by reason of sickness or unavoidable cause. Now, those words were present, as you will have seen, in one form or another from the 1870 Act onwards. Unavoidable cause, you'll note, has been interpreted strictly as something in the nature of an emergency. And one sees that from Jenkins and Howell, which is in Authorities Bundle 1, tab 32, MS 531, referred to at paragraph 35 of our case.
Is there a flavour in subsection 2A that of the idea that you're looking at a particular time?
Yes.
Yes, we would respectfully say there is. It's one of the points we make. It does talk about here, by reason of his absence from the school at any time, if the parent proves that at that time the child was prevented from attending by reason of sickness or unavoidable cause. Then subsection 3 sets out the list of statutory excuses, and those and the other excuses set out in the following subsections are the only available excuses. And one sees that from the case of Spears and Warrington, which is Authorities Bundle 1, tab 33, MS 539. Now, subsections 3A to 5 deal with travel arrangements, and they provide exceptions to the offence where a local authority is obliged to provide travel to school and doesn't do so. Now, subsection 6 is relied upon by both sides, and it deals with the case where the child has no fixed abode. In that case, there is a defence if the parent proves that A, his trade or business requires him to travel from place to place, B, the child has attended as regularly as the nature of that trade or business permits, and C, for children of 6 and over, the child has made at least 20 attendances during the period of 12 months, ending with the date on which the proceedings were issued. Now, the respondent says, and this is at paragraph 21.3 of his case, that this is a context in which regularly does not mean on each occasion when attendance is required. But we say, with respect, that is a bad point, because the phrase used in 4446 is not regularly, but as regularly as the nature of that trade or business permits. That is a phrase which qualifies the word regularly, whereas by contrast in section 4441, the word is unqualified. There's also another point, which is that if one looks at 4446C, that provides an example of the kind of statutory language used where Parliament wishes to specify a broader period over which attendance is to be judged. Where it wants to do that, it specifies the period, 12 months, that is, ending with the date on which the proceedings are instituted, and it specifies the minimum number of attendances, 200. Then there is 4447, which again is relied upon by both sides, and it makes specific provision for boarders. Now, for them, the child is taken to have failed to attend regularly if he or she is absent without leave during any part of the school term. Now, again, the respondent says, and this is paragraph 24.1.4 of their case, that the same language could have been but wasn't used in 4441. Again, my lords, my lady, we say that's a bad point. The same language could not have been used for day pupils because day pupils are not required to be at school for the whole of the school term. They are required to be at school only at certain specified times, specified, that is, by the governing body of the school or the LEA. It would also not have been precise to use the words in section 11 of the 1876 Act. You'll recall those words, every time that the school is open, because, as must be obvious, schools are open at times when pupils are not required to be present, for example, for teacher training or for optional extracurricular activities. Nor would it have been completely accurate, at least in the modern era, to use the formula adopted in some of the bylaws. The whole time for which the school selected shall be open for the instruction of similar age, because schools might be open for classes that are required for only some children of the relevant age. For example, special classes for those with special educational needs. Now, doubtless, Parliament could have come up with some formulation that would not have led to us all being in this court today, but that is, with respect, always the case whenever a point of statutory construction ends up in this court. The question is what Parliament actually meant by using the word regular, and we say that section 447 actually points to our construction rather than the respondents. Why do we say that? Well, we say that because on the respondents' construction, section 447 would give rise to an anomaly. A parent who takes a boarder out of school without leave for a holiday during term time, let's say exactly the holiday that was taken here, 7 consecutive school days, would necessarily commit the offence, whereas the same parent would not necessarily commit the offence if he takes a day pupil on the same unauthorised holiday. Now, the respondents have not been able to suggest any plausible policy rationale for that difference in treatment, which does not arise on our construction. And then subsection 8, as you can see, limits the penalty for the section 4441 offence to a fine not exceeding level 3 on the standard scale, which is currently £1,000.
Would you just go back to 6 for me for a minute?
Yes.
Mr. Chamberlain. 6B.
Yes.
You've made the point that the regularly there has an as in front of it.
Yeah.
But I'm not quite sure. Are you agreeing that in that sub-paragraph, regularly means often or frequent or not?
Well, what I'm saying is that regularly has exactly the same meaning there as it has anywhere else.
Yes.
But when qualified, as it is in that phrase, by the word as regularly as the nature of the trade or business permits, the composite phrase has a different meaning.
So it's as nearly as required as the trade or business permits.
Exactly.
As much in accordance with the school rules as...
Possible, yes.
I follow.
Exactly.
That's what you say it means.
Yes, and we do say that the complete absence from section 4441 of any similar qualifier does point in our direction.
It's little c that deals with regularly in the other sense.
Well, yes, exactly, and that makes the point that where Parliament wants to tell you, don't worry, it will be enough if you've attended this number of sessions in the past year, it tells you that in terms. Of course, in this case, you have to have attended that number of sessions.
It's telling you've got to do that and not just...
And you have to have attended as regularly as possible. So it obviously depends how much travelling the parent is doing.
I mean, that provision goes right back to 1870, doesn't it? Certainly to the early period.
It does. I
For
need to
itinerant workers.
find the exact provision, but it certainly has a history.
Yeah.
Now, there are then 3 other features of the statutory regime outside section 444 itself, which we say are relevant. They are sections 444 capital A and B, which establish the penalty notice regime. Section 446, which provides that proceedings for the Section 444 offence or offences shall not be instituted except by a local authority. And 447, which provides that before instituting proceedings under Section 444, a local authority has to consider whether it would be appropriate instead of, or as well as instituting proceedings, to apply for an education supervision order with respect to the child, and that is an order under Section 36(1) of the Children Act 1989, which you have in Authorities Bundle 1, Tab 10, MS 314. Now, our points about these are set out at paragraph 70B and C of our case, which is in MS 72, core volume MS 72. We say this, we say the fact that prosecutions are to be brought exclusively by the local authority is a significant safeguard. It means that there cannot be, for example, private prosecutions. And there was a similar provision to this in section 40, subsection 2 of the 1944 Act, which you have at MS 304. The same is true of the requirement to consider whether to apply for an education supervision order. That's a safeguard, because thought has got to be given at the time of or before instituting proceedings for the offence, whether that would be a more appropriate route or whether it's something that should be done as well as proceeding under Section 444. And there's also the limitation of the penalty to a fine not exceeding level 3 on the scale. Now, these points were all considered by Lord Justice Maurice Kay in the context of a challenge to the compatibility of Section 444 with Article 6. And that case is called Barnfather, Authorities Bundle 2, Tab 39, 603, at paragraphs 30 to 31. I'm not going to read those paragraphs, but I'll just invite your lordships and your ladyship to read those paragraphs.
I've got the wrong reference. Give me it again. Page.
Sorry. 616.
Yeah. Wants to
Yeah.
read that.
I would like you to read that, yes, my lords, lady.
A point that has occurred to me in relation to the convention and simply as a matter of statutory interpretation also, which is really a point for Mr. Sheldon, but perhaps I can raise it with you to give him an opportunity to think about it, is how, on his construction, Section 4441 would be compatible with the idea of legal certainty in relation to criminal offences.
Well, I am coming on to that.
You're coming to that, very well.
Yes, because it's actually a point that my learned friend, or my learned friend Mr. Greatorex, made below. One of the points he made below, before the divisional court, he obviously had two strands to his argument. He said, strand one, the magistrates were entitled to find as they did. Strand two, if I'm wrong about that, the offence is bad for uncertainty. And he invoked Article 7 of the Convention and said, well, this is an uncertain offence. And we do say, and I'm going to come on to it in just a moment, that on my learned friend's construction, it would be a radically uncertain event.
Yes, that's the point, really. It isn't simply that it's a matter of fact and degree for the magistrates, but there's a more fundamental uncertainty about it.
completely fundamental, so that a parent has absolutely no idea whether taking a week's holiday will constitute the offence or not. It just depends on what the magistrates decide.
Well,
So in
and
Crumpen,
also, I mean, taking a day wouldn't be an offence, really, at the time you do it. But if you then take another day the week after, and another day the week after that, and at some point or other, the offence is committed, and the offence would comprehend the very first absence.
yes, it is an odd position, and of course there's another point, which is over what wider period does one range?
Yes.
Normally when you have an information, it specifies the period during which the offence is said to have been committed. And one looks at that period specified in the information and asks the question whether attendance has been regular over that period. On my learned friend's construction and on the divisional court's construction, you have to look to a wider period. Well, what wider period? Yeah. A term, a key stage, a year, a calendar year, an academic year? It's very unclear. And if it's an academic year, I think this picks up the point that my Lord Regis put to me now. If it's an academic year, well, does that mean that a holiday taken in September will constitute the offence, but a holiday taken in June won't? Seems rather odd.
Yeah, there may be I haven't looked at it, but there may be an issue also about time limits for bringing a prosecution.
Well, generally speaking, the prosecution would have to be brought within 6 months.
Of what?
Well, again, it becomes very difficult on my learned friend's construction. None of these problems arise, as we say, on ours.
And does it affect the position whether there has been a prior absence for a good cause, for sickness or other unavoidable cause? Because all we have is a subsection which says that absence itself shall not be a failure to attend regularly. But if you pile on top of that a week's unauthorised holiday, do you take into account the fact that this may lead to an irregular attendance or not?
Well, my Lord, that is another of the difficulties that we've identified in the case, because, of course, the one and only reason given by the magistrates in this case for finding that the attendance in this case was regular was that 90% was, when one looks at the form, 90% is okay. But, of course, that was referring to absences both authorised and unauthorised. Yeah. So if somebody had happened to be unlucky enough to be ill for a substantial period, yeah, one then takes it below 90%. Does that mean that the same holiday does count, yeah, as commission of the offence, depending on? It's a very odd construction. My lords, my lady, can I just come back? I will come to the uncertainty point in due course, but can I come back to the penalty charge regime?
Yeah.
The penalty charge regime provides, and you have this at page 343, for penalty notices which do not give rise to criminal liability, and if paid, discharge any liability to criminal conviction. One sees that from section 444 capital A 2 and 4 on MS 343. The second feature is that the regime provides for regulations governing the issue of penalty notices. And one sees that from section 444 capital B1. Now, the regulations made under that provision, which you have in Authorities Bundle 1, tab 21, MS 383 and following, prescribe a modest penalty, £60, rising to £120 if it's not paid within 21 days, and require each local authority to consult and then draw up a code of conduct dealing with various matters, including when a penalty will be issued and how many penalties can be issued in a 12-month period. That's Regulation 14, which you have at MS 391. Now, the Code of Conduct for the Isle of Wight you have in the core volume, and that's in MS 249.
What happens if it's not paid within 28 days? Because it says £120 where the amount is paid within 28 days. What happens then?
Well, then what happens under regulations is that the council has to either withdraw the notice or prosecute.
And the prosecution could be any fine, could it? I mean, it could be a higher than £120 because you're not claiming the penalty then.
Then you're not paying the penalty.
It's level 3, isn't it? What's the top
It's
limit for that?
£1,000.
£1,000.
So
Okay.
that's right. The penalty notice is separate from the prosecution. It is not itself. It does not itself. The payment of a penalty notice does not itself involve any acceptance that a criminal offence has been committed. It simply discharges the payer's liability to conviction. And one sees that, as I said, from 444A, 2 and 4. There is then provision for the Secretary of State to give guidance in relation to penalty notices. That's 444 capital B 3. And he has done so. And that provides that before prosecuting, a local authority should consider the Attorney General's guidance for Crown prosecutors. You can see that at Authorities Bundle 3, tab 62, MS 978. And if you look at 981, for what it's worth, and we accept in this context the answer is not much, it also provides that one-off instances of irregular attendance, such as holidays taken during term time without the school's permission, can justify a penalty notice. The reason I say it doesn't add much is, of course, because we're trying to construe the statute, so that can't be driven by what the Secretary of State says. But in the context of an allegation made against us that our construction doesn't accord with what the Secretary of State has been saying, we say it's relevant at least to that extent. Now, we accept, of course, that the penalty notice provisions were not in the original version of the 1996 Act, and obviously they were not in the 1944 Act. We also accept that they apply only to schools that are publicly funded. That follows from the requirement in section 444A 1A little Roman 1 that the offence must relate to a relevant school, and relevant school is then defined in section 444 capital B 4 on MS 345 in terms which exclude independent schools that are not state funded. But subject to those...
Where's that excluded?
I'm sorry, so it's...
Where's the phrase independent school?
Well, it's my interpolation. It's, if one looks at 444B4, that includes a whole list of schools. It includes an academy school, which is technically an independent school, but state-funded.
I'm with you. Okay.
However, subject to those caveats, the penalty notice regime does, in our submission, provide significant legal constraints on the exercise of prosecutorial discretion. Like the statutory features identified in Barnfather, these constraints make it less likely that a prosecution would occur for a very minor offence. Indeed, in this very case, a prosecution would not have occurred had the penalty notice been paid. Now, apart from these textual points, there is an important point, we say, about the construction adopted by the Divisional Court, and this is my Lord Reed's point, in which regular attendance is a question of fact and degree, and we address that at paragraph 71 of our case. The consequence of the construction was, in fact, and just show you, your lordships, your ladyship, this, highlighted by the respondent below, and it's in the core volume MS 221, as part of his argument before the divisional court. Paragraph 41 of his case, he says this: "Put simply, it is not sufficiently clear and certain for a parent to know before taking his child out of school whether that is criminally forbidden." And it certainly was not on the facts of this case. We say amen to that, but only if you adopt the respondent's construction. If you adopt ours, there is no uncertainty at all.
Yes, the point's made in a nutshell. In 40, subparagraph, yes, in second sentence of paragraph 40, that in the absence of a definition of the term or of a reference period by which it is to be judged,
Yes.
regular is far too vague to be the basis of a criminal offence.
Yes, indeed, and we respectfully adopt that as an argument against the construction now favoured by the respondent. Now, we've set out at paragraph 71 of our case the anomalies that could arise from the respondent's construction. In Crump's case, both the magistrates and the divisional court thought that 12 absences out of a possible 114 gave rise to a failure of regular attendance. 12 absences, we're talking, when one looks at numbers of absences, these are session absences, so there are 2 per day. So that's 6 days absence out of 114 possible attendances, 57 days attendance. And that, on the view of both the magistrates and the divisional court in Crump, amounted to a failure of regular attendance. In London Borough of Bromley and C, which is the case on which the divisional court relied here, the divisional court there took the view that 18 absences out of, where you had 18 absences out of 114, there was only one conclusion open to the magistrates. The magistrates had acquitted in that case, but there was only one rational conclusion open to them on those facts, namely that there had been a failure to attend. But if the divisional court's construction in this case is correct, then it's open to the magistrates to say that 0 out of 14 is acceptable when looked at in the context of some wider period. And again, the point I've just made in answer to my Lord Reed's questions, but if one is entitled to look at the wider period, what is the wider period? Term, calendar year, or whatever. And one sees, of course, having looked at section 4446, that where Parliament wants to specify a wider period, it does so with precision, so that you know what period you're looking at. And the period in section 4446 is the period of 12 months immediately preceding the date on which the proceedings are instituted. And one can see a certain fairness in that, but there is nothing of that kind here. So we do say that these difficulties and anomalies support our construction, on which the meaning of regular attendance, though strict, is also clear, both for parents and for the local authorities who have to administer this scheme. My Lords, my Lady, the alternative case that we advance is set out at paragraphs 73 and following of our printed case, which is in MS 75 to 6. Now, you will see that the respondent says that this alternative case is not open to us because it was not included in the application for permission to appeal. We've responded to that at paragraph 7 of our written case, and I'm proposing to say nothing more about it at this stage, although I will come back to it in reply if I need to. The alternative case is essentially a variant of the primary case, and it is very simple. If regular attendance doesn't mean attendance at all times when attendance is required, or attendance, as per my lady, in accordance with the school rules, then for all the same interpretative and historical reasons, it must mean something very close to it, or as my Lord Neuberger put it at one stage, attendance subject only to de minimis absences. even if the question of regular attendance is, as the divisional court held in this case and in the case of London Borough of Bromley and C, a question of fact and degree, there must be, as the divisional court's judgment in C shows, some limits to the magistrate's discretion on that question. Now, as I've said, in C's case, the period specified in the information, just ask you to look at C's case, because this is the authority that was relied upon by the divisional court in our case for the proposition that the question of regular attendance was a question of fact and degree. So if one looks at Authorities Bundle 2, tab 45, MS 723, and then if one then goes forward to paragraph 21, actually looking at paragraph 19 on 732, the period specified in the information spanned 57 school days, and the holidays amounted to 9 of these.
Where does it say the first sentence? Where, the 57?
The end of 19. The question will be very much one of fact and degree in each case.
I take 19.
Sorry?
In order to mount this argument, you surely have to grapple with the question raised in Mr. Greatorich's case, which we heard a moment ago, as to what is the base period.
Yes.
On one view, you should wait to the end of the school career and see whether there was regular attendance during the school career. Alternatively, what do you take? A year? Yes. A term?
Well,
is there any clue in the statute to help you mount this alternative argument?
Well, let me put it this way, that what one sees in this case is the court looking very specifically at the period specified in the information.
We can also see, can't we, why the period was specified as it was. If you go back to 726, you'll see effectively the facts set out. And there were 2 holidays which are separately listed in subparagraphs N and O, one in November 2003 and the other in January 2004.
Yes.
Unless I'm much mistaken, the period specified began with the beginning of the first holiday and finished with the end of the second holiday.
Yes.
Is that right?
Yes.
So that's where it came from.
Yes. Yes.
On the other hand, how it's chosen, presumably, is a matter entirely for the
prosecutor,
framer of the information.
Yes. And so,
that can't be a justifiable basis for conviction.
well,
Can the framer choose anything he like? Could they choose the 1st of January 2003 in this case? Or the beginning of September, whenever the school term begins?
Well, subject to the 6 months.
I mean, on our primary construction, we say, as you know, regular means in accordance with the school rules. So then the framer could choose the 1st of January, or if that was a school day. One assumed 1st of January normally isn't, but the framer could choose any day, which was a school day, and specify that day, as in the cases where Ascension Day was chosen as the day.
But on your primary construction,
on the primary case, that's right. On our alternative case, we are still saying that it is up to the framer to choose a period, and as long as that is a period during which it is meaningful to ask whether attendance has been regular, then one's limited to the period. And that
is an impossible, surely, discretion to the prosecutor to shape the facts in a way which helps the prosecution.
Well, it depends, doesn't it? If one comes to the view that regular means, and this is the, if you like, the condition for success of our alternative case, that regular, although it doesn't mean each and every occasion, it means something very close to that, subject only to de minimis absences. So in other words, it would prevent the offence being committed in the circumstances mentioned by my Lord Newburger, where you have a couple of attendances that are 5 minutes late. So those are de minimis, and therefore they don't prevent attendance from being regular. But it is still the case, we say, that you've got to look at the period specified by the prosecutor and ask whether attendance has been regular during that period. That's what was done in the case of C, And actually, although the divisional court in this case thought that the court in C had looked at a wider period, on the facts, they hadn't looked at a wider period. They'd looked at precisely the period specified in the information, and they'd asked whether during that period attendance had been regular. And the answer
The actual period, I'm sorry, I was slightly wrong.
Yeah.
The actual period is on the previous page, 725, paragraph 1 of the case, and it actually ended not with the end of the second holiday, but about 3 weeks later.
Yes, yeah, slightly longer.
But so quite where that date came from, heaven knows.
Yes. Well, this is always going to be the case, that where one has an offence, which can in principle be committed over a short period or a long period, the question whether the offence has been committed is going to depend in part on the period chosen by the prosecutor. That's the nature of a prosecution. The court has to look at what is put before it in the form of the information and ask whether over that period there has been a failure to attend regularly. The only point we make on our alternative case here is if one looks at what Mr. Justice Sullivan says for the Divisional Court at 21, he says that this period, that is to say 9 absences over 57 days, could lead to only one conclusion, that is to say there had not been regular attendance. For every 4.5 attendances, the children had been avoidably absent on holiday for 1 attendance. So even though the question was one of fact and degree, this was a case in which the Divisional Court could properly and did interfere with the magistrate's conclusion. And we say the present case is such a case as well. Present case, obviously, one where there was 7 consecutive school days. The period specified was 13th to 21st of April. We say there's nothing wrong with that period on the face of it. It's a period during which one can perfectly, properly and meaningfully ask the question, has attendance during that period been regular? And there is only one answer to which can be given to that question, and that is no. My Lords, my Lady, can I briefly deal with some of the points that are taken against us in my learned friend's case?
Yes.
And I do it briefly. The first point taken against us...
Very briefly, because on the whole it's more useful to hear you in reply once they've put their case.
Yes, well, perhaps I can just limit what I say to 3 or 4 points, if I may.
Very well.
The first is that in some usages, regular means reasonably frequent. And it's said against us, for example, that if I'm a regular attender at Chelsea Football Club, that doesn't mean I go to every single match. As to that, Lords, my Lady, we say obviously it can mean that in some usages. The question is what it means in this
They
context.
presumably don't have any rules that you have to go to each match. But
exactly.
you might be a member of some debating association where it was a rule that members would attend on each occasion.
And that would be the closer analogy. The second point taken against us is that our case starts from what the respondent calls a flawed premise. It says this in paragraph 60, that we are wrong to link the interpretation of the offence in section 4441 to the duty in section 7. We say that is a bad objection because in the 1996 Act, as in the 1944 Act, the duty and the offence both use the same concept of regular attendance, and the concept must have been intended to mean the same thing in both sections. That purpose, the purpose specified in section 7, namely to cause one's child to receive efficient full-time education, is relevant, as Hinchley and Rankin shows, to the definition. Third point taken against us is the point about that Parliament could have used different words. Again, we say, obviously, it could, but it is actually quite difficult to come up with a formulation that exactly specifies what our construction of regularly achieves. Now, I do need just to address this point, because it is a legal point that's taken against us, by reference to the principle against doubtful penalisation. And what is said here is that if regularly has two possible meanings, which we accept it can do, the principle against doubtful penalisation applies so as to require the court to adopt the meaning that is most favourable to the defendant. Now, we deal with that at paragraph 72 of our case on MS 74. Now, there are a couple of authorities referred to there. Probably the best authority there is Lord Reed in Ottewell's case.
You set it out.
Yes, we set it out there.
If it's there, we might as well take it from there.
And we say if one applies that guidance, one can see it's not enough to say that a word can have two meanings. It is, he says, difficult, extremely difficult to draft any provision which is not ambiguous in that sense. The question is whether the court is satisfied after full consideration, i.e. given the statutory history and the other textual and contextual points that we make, that the provision means what it says, what we say it means. And if so, the principle against doubtful penalisation doesn't prevent the court from adopting that meaning. Yeah. And we say much the same result flows from the application of the principle in Benyon, yes. That the penal enactment will not be given a strict meaning, by which he means in context there a meaning favourable to the defendant, if other interpretative factors weigh more heavily in the scales.
Basically, as I understand it, what you're saying is that this principle is a tie break, and you don't get to a tie here.
That's exactly it. My lords, my lady, I see that I have another 5 minutes, but I have finished those submissions that I need to make. I may need to come back to some other points made in some other more detailed points made in the case against me, depending on how those are developed in oral
Well, you may
submissions.
need to reply. Yes, I understand that. Thank you. Yes. Mr. Mackenzie. Streedy.
My Lords, my Lady, the Secretary of State's policy is underpinned, unsurprisingly, and we submit consistently with the legislative scheme, by the fundamental aim of seeking to ensure and support the provision of compulsory full-time education for children. It probably requires no detailed research to support at least three basic propositions, and we submit that each of them is relevant when testing the respondent's argument and its consequences to see what they tell you about likely parliamentary intention. The first of them is that absence from school directly and adversely affects a child's educational attainment. The research, if necessary, indicates that every extra day missed was associated with a lower attainment outcome. See our case at paragraph 6 and footnote 1, and the references, if you want them, are in volume 3, tab 63, MS 986. Secondly, absence is liable to disrupt not merely the absent child's education, but that of other children also. Disruptive, no doubt, in its own right, and disruptive because of the extra burden on teachers and the school in ensuring catch-up. And in relation to both of those first 2 points, for obvious reasons, the longer the absence, the greater those concerns are. Put that in a little context. A maintained school has 190 school days in the academic year, and a 91% attendance rate equals 17 missed days. And it might be thought that to that point can be added that the more pupils who may be absent, the greater those concerns are. The third basic proposition is this: undermining the authority of the school or the head teacher and those with responsibility for running the school is likely to be a thoroughly bad thing? The question in this case, it might be thought when one strips away all the legal technicalities about the period covered by the indictment, is this: does a parent have a right, in the absence of a correlative duty, to take their child out of school during term time for any reason they judge appropriate, in this case for the purpose of going on holiday to Florida, and to do so irrespective of the judgment of the school as to whether or not authorization should be given? There is a rider to that question, and the rider is so long only, on the respondent's case, as the child has not, brackets, for whatever reason, been absent, and I put this next bit deliberately vaguely for reasons you'll understand, has not been absent too often beforehand. The question is whether that was Parliament's intention and whether that is the effect of the legislation. And specifically, it might be thought, given that the relevant parts of the legislation bearing on the issue of interpretation before you were set in 1944, whether that was the intention of Parliament at that time. And we submit not. I'm not going to take you through all of the points that we've made in our case. I'm going to focus orally on only two particular aspects of the relevant development of the legislative regime. And the first of those aspects is the legislative history of the duty on parents to secure attendance at school, set out particularly extensively in my learned friend Mr. Chamberlain's written case. But it is of some interest, perhaps, to the issue of interpretation to split out the various strands of the legislation and to see how each of those strands, each of the concepts, came to be as they were in the 1944 Act in particular. The first change that was made by the 1944 Act was as to the nature of the education. It effected a change, in effect, to require broader and deeper education. At all points from 1876 up to and including the 1921 Act, Section 42 of the 1921 Act, the duty on the parent was to cause the child to receive efficient elementary education in reading, writing, and arithmetic. That was the form of words that was pretty much constant up to and including 1921. So if you want the references, I'm not going to invite you to go back to them, but the 1876 Act, Section 4, 1921 Act, Section 42. The change made in 44 was to remove the adjective and the limited description of education. So elementary was dropped, as were in reading, writing, and arithmetic. And the effect was that the duty applied more broadly to education generally, no doubt reflecting the legislative intention at that time to secure for children what I described earlier as broader and deeper education.
Well, suitable to age, ability, and aptitude.
Exactly so.
That was what was introduced, wasn't it?
That was what was introduced, but it isn't limited by subject matter, and it isn't limited by the adjective elementary. Right? And that is all consistent with the legislative intent at that time, which was to ensure and secure fuller compulsory education for the child's benefit. And one sees that if you want it. It's evident from the provisions and the nature of the change, but you see it in terms and expressly using fuller, the adjective fuller, in paragraph 1 of the white paper that you have that preceded the 1944 Act. So that was one of the changes that was made. But to focus more directly then on the specific duty on the parent to ensure that children attended school, the position was this. Between 1870 and again up to and including 1921, the nature of the duty was essentially the same. The legislative history went section 74, 1 and 2 of the 1870 Act, became section 2 of the 1880 Act, became section 46 sub 2 of the 1921 Act. And what that history indicated was that there was, first of all, a power and then a duty on local authorities to make bylaws. The purpose of those bylaws was specified. It was to impose a duty on parents to cause children to attend school. The nature of the requisite duty was in effect the same. It was a duty on the parent to secure attendance, quote, at such times as may be determined by the bylaws. And so, of course, when one focuses on those words, one sees that under the primary legislation, the enabling power and then the duty, bylaws at the very least could set the hours of the day, the term dates, and require attendance throughout. For want of a better summary, require education that was full-time. And as a matter of fact, we know from the helpful summary of the history of Mr. Chamberlain's case that bylaws of precisely that kind were in fact made. The 1944 Act was then enacted, and it replaced both Section 42 and Section 46 of the 1921 Act, with its duty to make bylaws. And now, in the 1944 Act for the first time, the temporal nature of the education was actually specified in the primary legislation, full-time. And just focusing on that change, there was, of course, a change in the removal of the bylaw-making duty, but Parliament will at least can be taken to have known in 1944 that some, perhaps many or even all, had bylaws specifying full-time attendance. And Parliament, which now assumes the role to set the nature of the duty in the primary legislation, chooses to use the concept of full-time for the first time. And that was the concept, as we've just seen, which was at the very heart of the structure of the old bylaw-making regime. What Section 36 of the 1944 Act then does is to provide alternative ways in which that duty, the full-time duty, can be complied with. The duty remains a duty to cause the child to receive a full-time education. Full-time, therefore, remains the governing concept in the content of the duty in Section 36 of the 44 Act. But if you are at school, alternative one, that duty is complied with by regular attendance.
Yep.
If not, you can conform to that duty, in other words, full-time, without any addition of regular attendance. Otherwise is the word used. That's the second alternative. So the features, when one analyses that that's the nature of the development of the regime and one sees the structure of Section 36, the features of the concept of regularity under this scheme, the 1944 Act scheme, which is the relevant modern-day precursor, are these. Regular is not being used as a qualification of the apparent breadth of the governing concept of full-time. It serves a different statutory purpose which does not touch or diminish the force of that concept. It is evidently not designed to water down the rigour of the concept of full-time. And that is because not merely the structure of Section 36 indicates that with its alternative mechanisms of compliance, but we've already seen that full-time was introduced to replace by primary legislative provision the enabling power or duty to make bylaws that could have and did in fact provide for attendance at all times specified by the Education Authority. And so regular attendance and its reference is simply one of two ways of complying with that duty, whose content is to secure full-time education. So that's the specific duty on parents and its development to ensure that children attend school. Turning then to the offence-creating provision, under the 1921 Act, penalties could be imposed under the bylaws for breach of the duty to cause children to attend at such times as may be determined by bylaws. That's Section 46.2 and 46(6) of the 1921 Act. And the respondent accepts, I think, that under this regime, and indeed the ones that preceded it, that's the 1921 Act, any failure to attend as required was to be penalised. We respectfully submit that the 1944 Act is no different in that respect. A couple of reasons perhaps for that. Firstly, section 39(1), which is the offence-creating provision in the 1944 Act, is not to be regarded, we submit, as creating some freestanding offence not directly linked to the duty in section 36. The offence there created applied only to those who chose to secure education through the school route. It is therefore unsurprising that that is section 39, the offence-creating provision, used the concept of regularly. But it is plain that that concept in section 39 can't be disaggregated from the nature of the duty in 36, for the obvious reason that 39 is the enforcement mechanism for the duty in 36. The technique of the legislation is perhaps neater in section 39 because all the offences are dealt with in one place, because the legislative coverage is greater and more complex. But it is in substance no different to the position as it had been under 46(2) and 46(6) of the 1921 Act, and the link is plain on the face of the 44 legislation. And the concept is the same. Regular is used in section 36 and in section 39, and it is evident from that fact alone that they were intended to mean the same thing. It would be a bizarre choice of wording otherwise. The point that leads to, however, is that once the respondents accept that under the old regime it was any failure to attend, a legislative purpose question arises in relation to the 1944 Act on their case. Why would Parliament have chosen to soften the regime? Where are the interpretive indications that Parliament so intended? There are none. And to assert that they intended to create a change significantly to water down the duty is, we respectfully submit, positively inconsistent with the overall aim of the 1944 Act to further and more tightly control effective, efficient, compulsory education for children's benefit. So that strand of legislative history on the duty of parents to secure attendance at school, we respectfully submit is of real interest for those reasons. The second area I wanted to focus on is the legislative treatment of acceptable reasons for non-attendance. And again, the history here goes from section 74 of the 1870 Act, materially, to section 49 of the 1921 Act, to section 39 of the 1944 Act. And if you go back to that little sequence of provisions, those are the places you find it in the legislative sequence, that history indicates a hardening of legislative position, or putting the same point the other way, a narrowing of things that are deemed acceptable as excuses for non-attendance. The position in summary was this: up to and including the 1921 Act, the position had been that there were a list of things that would be deemed to amount to reasonable excuse, but the door was left open by all the legislative schemes up to and including 1921. The door was left open to a defendant to argue that other matters might represent a reasonable excuse. There was then a conscious change in 1944. What you have in the 1944 Act and thereafter is an exclusive list of matters. Only they will do. And the nature of that change between those bits of legislation, 1921 to 1944, was noted in terms in the case that my learned friend Mr. Chamberlain referred you to, Spears and Warrington, Volume 1, tab 33. And within that framework, the 1944 framework, as we also saw this morning, the exhaustive concepts themselves, now an exclusive list, as it were themselves strictly interpreted. One only has to go to the facts of cases like Jenkins and Howell, Volume 1, tab 32, where a child was absent because of a partially sighted parent, and that was deemed not to be good enough to be an unavoidable excuse, to see how strictly even those exhaustive concepts were themselves interpreted. So there are two relevant points flowing on the history, so far as those matters are concerned. Firstly, Parliament is evidently increasing the stringency of the duty, no doubt with a judgment of the best interests of the child squarely in mind, and that sits inconsistently with a suggestion that the overall thrust of the 44 Act was consciously to relax provisions bearing on that duty. And secondly, Parliament is also making conscious legislative choices about what is and is not an acceptable reason for non-attendance of a child. Turning from the history to the present position, you saw this morning, and you've looked, I know, at section 444 already, but you will have seen that there are two offences created in 444 under the current regime. The one which requires knowledge of a failure to attend regularly has, and significantly has, a broader defence of reasonable justification, 444 1A and B. You saw that, capital A and capital B. Yeah. And what that does, therefore, is when you go back to the legislative history and trace it through, we can see now that what that does is to replicate, but only in relation to that more serious offence, the 1921 Act provision. Just look to see whether the excuse that is given amounts to a reasonable justification. But the strict liability offence with which we are concerned does not. It replicates the strictness of the 1944 Act. So under the current regime, there are limited and exhaustive situations in which a child is deemed not to have failed to attend regularly. And they're set out in 4442, capital A, and 4443. There is a clear indication, therefore, that under the current legislation, in relevant part, strict legislative policy in that regard, i.e. what amounts to a good reason for a child not attending, has continued. We also know, in relation to reasonable excuses, that there have, since the outset, been provisions which correspond to the present version in 4443 little a, with leave. So there's a specific provision included within the now exhaustive set of conditions with leave. And that is, under the structure of 444, as we've seen, both a deemed reasonable excuse and an indication that the system of leave and the judgment of the person who is to give leave is considered by the legislature to be important. Unless you are within one of the other parts of the narrow and exhaustive list of acceptable reasons for non-attendance, leave is required. It's also perhaps to be noted that this excuse with leave introduces another element of flexibility into the regime, and as such now sits alongside all the other elements which my learned friend Mr. Chamberlain reminded you of in his submissions this morning. The regulations that deal with leave and holidays, the various codes of practice that are required to be produced, codes of conduct, penalty notices, and so on, the various other aspects of the regime introducing flexibility into what is otherwise a strict liability offence. So what then are the conclusions to be drawn in relation to this second area of focus, reasonable excuse? The first conclusion, it might be thought, is that Throughout the period of legislation, Parliament has been consciously focused on the reasons that might be put forward for excusing a child's non-attendance. That focus on what does and does not amount to a proper excuse for non-attendance is integral to the scheme, and we submit that it sits alongside and informs parliamentary intention when considering other elements of the duty, such as the concept of full-time and its related concept of regularity.
Can I just ask you, the concept of full-time education may be key to this. There's nothing in the Act itself or in the 1944 Act which defines what's meant by that, is there?
There isn't.
But there's a contrast between full-time education for people of for children of compulsory school age, part-time education for those who have reached the school leaving age.
Yes.
And entered the workplace. Has there been any judicial consideration of what full-time education means?
I don't think none that anyone has found, and we've all tried to have a look for that. Whether one can draw as much from the contrast between full-time and part-time that my Lord has referred to, that was part of the reason for wanting to focus on the legislative history, because what you see is, if you trace that through, that full-time sits, as it were, not as the replacement for some other regime that did that division, but it sits as the replacement for the bylaw-making power or duty, which did at least enable full-time in the strict sense to be deployed. But we're not aware of any case.
Yes, and part-time wouldn't be every day. I mean, employers were expected to allow the young people in their workplaces to attend college 1 or 2 days a week, weren't they? But are you saying effectively that full-time means every day when the school is operating?
That's exactly what we say. And we respectfully submit that only in that way does it replicate the previous legislative regime, which was in effect the power or the duty to make bylaws having precisely that effect.
Yes.
But the point that I'm on now is the slightly different one. It comes at it slightly tangentially by asking about a different set of concepts, but it's immediately evident what the crossover might be between what Parliament has deemed to be an acceptable or a reasonable excuse for non-attendance and how one approaches the other concepts. It doesn't lead directly to the answer, but it is of some interest for reasons I'll develop very briefly, if I may.
Yes, and there will be legislation which imposes a requirement that schools have to comply with in terms of the number of days education they offer and so forth.
Yes, I'm not sure what that legislative scheme looks like, but
yes.
I'd be surprised if it was.
Yeah.
Okay. I mean, however that works, you'll end up with a set of judgments and selections as to appropriate times and days and so on. And the question then is, once that judgment, as it were, a prior judgment has been made, how effectively does it work thereafter? So there's a sequential point.
Can I just ask, following up Lord Reed's questioning, if the word full-time hadn't appeared there, then one would be looking for something which at least gave a power to specify, on your case, one would be looking for something which at least gave a power to specify when people should attend a school. And if one didn't find that in a bylaw, one might expect to find somewhere in this statutory scheme some authority given to teachers and head teachers. I mean, is the word full-time so essential? Is there not somewhere in the legislation something which says that teachers have certain powers?
My Lord, I think my own friend's right. He's reminding me that in footnote 18 to his case, Mr. Chamberlain's case,
right,
I think you've got a collection of legislative provisions dealing with those powers.
Sorry, footnote 18.
Footnote 18 on MS page 60.
Yes.
Yes.
Right. Yes. So, I mean, full-time may not be so critical as you're suggesting to your case, because
You could still have regularly in there.
you couldn't run a school system unless you had some defined times at which students were supposed to be there and work.
My Lord, yes. I don't think either of us suggested it's critical to the argument, but if one is looking for indications in the legislative scheme,
No, I mean,
and you trace
it
the
helps
development
your
through, it gives a
argument
flavour.
perhaps on regularity. Yeah.
Yeah. The point I'm on now is the reasonable excuse provision. And the first point I was making was that throughout the legislative history, Parliament has actually focused on the reasons that would or would not excuse non-attendance. It hasn't been neutral on the reasons for non-attendance. On the contrary, as we've seen from the development, it's been strict. It requires a reason rather than no reason for non-attendance. It requires that that reason should fall within the narrow and exhaustive list that it identifies. That's the first conclusion, therefore. The second conclusion is that Parliament has also placed the judgment as to any broader reasons in the concept of our strict liability offence, beyond those expressly specified for non-attendance, in the hands of the school, not the parent. There is no deemed reasonable excuse where the parent judges it appropriate to take the child out of school. Still less is there no need to give any reason at all. And that is significant in my respectful submission for this reason. On my learned friend, Mr. Sheldon's case, he has to say that you have, on the one hand, deemed reasonable excuses very tightly drawn and including at its broadest a judgment of the school as to whether or not leave should be given. But that those reasonable excuses and that judgment applies and applies only when outside the concept, as he describes it, of regularity. And we saw that 91% equals 17 school days that can be missed without excuse. And so on his case, within that period, let's assume that that is at least a proxy for regularity on his case, but within the period of 17 school days, there is no control on his case based on the reason for absence. It could be a foreign holiday, and it may be thought that we all know that holidays at half-term and in school holidays tend to be considerably more expensive than at other times of the year. It could be, on his case, for no reason at all. Within that period on his case, therefore, a parent can choose, for good reason or none, to set his face against the considered judgment of the school. And within that period, all parents could do so. If one parent can do so with impunity, with giving no reason, so can others. So if the regularity period is, say, 17 days, a whole class could decide that the sun is out and that foreign climes beckon. And that, we respectfully submit, would be absurd. And more importantly, it would be thoroughly inconsistent with the basic thrust, purpose and aim of these legislative schemes from 1870 onwards. And of course, none of that absurdity, none of that inconsistency, and none of those consequences apply if our construction is the right one. My lady, those are my submissions, unless I can seek to assist further.
Thank you very much indeed, Mr. Reedy. Thank you. Mr. Mashley. Mr. Sheldon.
My Lords, my Lady, the respondent, Mr. Platt, resists this appeal, and he disputes both the primary and, if allowed, the alternative case put forward by the Council and as supported by the Secretary of State. The primary case brought by the Council is that a child fails to attend regularly at school if, without statutory excuse, he or she misses 1 day of school. According to the Council, regular attendance means attending on every occasion when the school is open for teaching children. The respondent says that this is wrong for 4 reasons. And in my submissions, I'm going to start out by summarising those reasons, and then hopefully after the short adjournment, I will deal with, firstly, how does the statutory scheme work, what we say it means. Secondly, explain the statutory history. Thirdly, discuss the case law. And fourthly, deal with the Council and the Secretary of State's submissions and arguments and address the alternative case. So firstly, I just want to deal with our summary arguments as to why their construction is wrong, and this is in respect of the primary case. First point is we say that their interpretation is contrary to common sense and the ordinary and natural usage of the words attend regularly. We say the ordinary and natural usage of those words is to attend normally, attend customarily, or attend usually. It could also mean to attend frequently.
Do you stand by the submission made below that that means that the words are incapable of sensible application because they're so uncertain?
The point was argued as a secondary matter, which was not ultimately dealt with by the Divisional Court, and I'm not going to be making that point here. They are sufficiently certain when the magistrate construes them in the context of all the available and relevant evidence and makes a decision on the basis of fact and degree, as was done here and as was supported by the Divisional Court in 2 cases. So one can have sufficient certainty.
What period, just to jump ahead?
Well, my Lord, if I can come back to that when I develop my submissions, otherwise I won't get through my summary points before lunch. As a matter of ordinary usage, we say first of all, a maintained school is open for 190 days. And we refer to that in footnote 3 of our case.
Thank you.
The requirement to to set a certain number of days, it's on MS 85, it only applies to maintained schools. There is no similar requirement for academies or for independent schools.
When the Act was passed, was that in the 96? Because I see you refer to subsequent...
No, this applies in regulations. And
yes, I see. But what I'm wondering is when the 96 Act was passed, is that right, or is it subsequent that that's been the case?
There may well have been something before. There may well. I only know about the 1999 regulations, but we can look into that, my Lord. But my Lord, a maintained school is open for 190 school days. We say, as a matter of common usage and common sense, a failure to attend school on one occasion would not be regarded as a failure to attend school normally, customarily, or usually, let alone frequently. Indeed, if the Council's construction is correct, and you heard their submissions about the case of Hinchley and Rankin, in terms of times at which you need to attend, the criminal offence would be committed if a child was late to school on one occasion. Now, one can get into arguments around de minimis, but that's the alternative case, not the primary case. Because the primary case is that one needs to attend at all times that the school is open, on every day in which the school is open. And if that is right, then the failure to attend is crystallised, is triggered, and a criminal offence occurs if a student is late by 1 minute on one day.
Do you agree that there is a duty to be there on time each day, or not?
Well, my Lord, there's not a duty in terms of a duty which is remediable by an enforcement mechanism.
That's a slightly different question.
And I don't regard there as being a duty, and I'll come on to develop that.
Okay. I must say I'm puzzled by your submission about de minimis. I would have thought it was intended to cater for situations where a rule was broken in a minimal way. Someone arrives a minute after the registers. Anyway, you say it isn't.
It doesn't, and it's the extension of the argument that's being made about Hinchley and Rankin, which is that one attends at every time, all the times that the school is open, that if one is late on one occasion, that would amount to a criminal offence. But I'll come on and develop that, my lord. But in any event, even if it's not being late on one occasion, it's not being present on one occasion, which we say is an absurdity when one looks at the language that is used. Secondly, we say that the construction being put forward is contrary to Parliament's intention and the statutory history. Had Parliament intended the construction that the Council and the Secretary of State prefer, they would, we say, have drafted Section 4441 or its predecessor, Section 39 of the Education Act 1944, entirely differently. There was clear language from the pre-1944 legislation in the context of the school attendance order regime that they could have used. Failure to attend on every occasion that the school is open, which would be interpreted, obviously, as is open for teaching the children, rather than is open as in the doors are open and teachers can come in and have some inset training. Alternatively, and this is not a point which we set out in our case, but the more one looks at the statute, the more one realises how obvious it is, Parliament could have done without use of the term regularly at all. Section 4441 could simply have read, if the council's case is to be accepted, if a child of compulsory school age who is a registered pupil at a school fails to attend at the school, his parent is guilty of an offence. Because that is their interpretation, failure to attend at school. Instead, Parliament has used the concept of regular attendance. And we say, given the obvious alternatives that were available, this has to mean something other than every time that the school is open. In addition to the language that Parliament could have used, we can see from the statutory history that the approach prior to 1944 was not as strict as the way in which the Council and the Secretary of State now wish to put the matter. My learned friend, Mr. Eadie, on behalf of the Secretary of State, says, actually, because he recognises this point, the 1944 Act made things more strict in terms of non-attendance. In fact, there was no material in the parliamentary materials to support that. But that's what his interpretation does. Firstly, as we know, and as I'll show you later, the school attendance order regime, which applies both to children who are not educated at school, but also to children who are educated at school. There's nothing in the language which suggests it applies to one rather than the other. The school attendance order legislation depended on showing a failure to attend habitually and without reasonable excuse. Now, the language of the school attendance order is fail to attend regularly. The bylaws, as my learned friend Mr. Eadie pointed out before, allowed a parent to show a reasonable excuse for their child not attending school. Parents were not confined to a list of statutory excuses. And we say the introduction of the concept of regular attendance was intended to lead to a conclusion that was broadly equivalent to what pertained pre-1944. Not to water it down, as is suggested against us, or is put against us, nor to make matters more strict, but broad equivalence. And the interpretation, therefore, of regular attendance has to be seen in that light. We also say, that until this case, in fact, until 2016, as far as we can see, the Secretary of State has never suggested that 1 day of absence means that there's been a failure regularly to attend. The guidance and other education legislation does not support that there has ever been such a view held by the Secretary of State. Thirdly, as my summary reasons, the Council's proposed interpretation runs counter to the consistent case law under Section 4441 and the predecessor legislation. It was well understood, we say, by the courts under the 1944 Act that 1 day of absence could not amount to the criminal offence. That is also the consistent case law under the 1996 Act, both from the Bromley decision and, of course, the decision from which the appeal is made. The fourth point, in summary, is that the Council and the Secretary of State's argument, the primary argument, offends against the principle of doubtful penalisation. At its very best, the Council's argument, we say, is one which would give rise to a doubt as to what was meant by Parliament. We say, of course, there's only one proper interpretation, but even if you're not with me, there is a doubt as to whether or not the matter is as we put it. And if there is a real doubt, the principle of doubtful penalisation requires the court to adopt a construction that avoids penalty. And if we just stand back and consider this, the effect of the Council's primary argument would be to criminalise parents on an unprecedented scale. We refer to this matter at paragraph 5 of our case, MS 80 and 81.
Yep.
In autumn 2015 alone, based on the government's figures, there were 4.1 million days of unauthorised absence in state-funded schools. 4.1 million days. If the Council and Secretary of State's argument is correct, there were 4.1 million, or possibly 4.1 million criminal offences committed during one term alone. Now, of course, if the government wishes to change the law to criminalise each of these days of unauthorised absence, then what it should do is, rather than come before this court and argue something which we say offends all of the principles that I've just set out, but to try and persuade Parliament of the merits of such a change and introduce fresh legislation to this effect. The reasons for unauthorised absence are numerous and varied. It includes days of sickness which are not accepted as such by a school because the GP has not provided a note, when it may not be the practice of a GP to provide a note. There will be special family occasions and travel to those occasions where leave is not granted, because the current provisions, my learned friend Mr. Eady says, well, reasonable excuse is now deemed by the leave provisions, but the leave provisions only allow the head teacher to grant permission in exceptional circumstances. And there will be special family occasions where one needs to travel there and back. If leave is not given, then that is regarded as a criminal offence on the council's case.
The exceptional circumstances, just give me the reference. Where's that come from? It's an instruction, is it?
No, my lord, it's in a regulation.
In the regulation, yeah.
It's in the leave regulations. I will have that for you later. In addition to family occasions, there will be sports tournaments and extracurricular events which involve travel to and from. A child may be part of a national team. They may have been awarded a prize where the head teacher may grant leave for the day but not travel to and from. And of course, as this case is concerned, there may be family holidays where the complex family dynamics and arrangements lead to the possibility of a holiday with all the family in term time. So, my lords and my lady, those are my summary points, and I will seek to develop those after the adjournment, but I can carry on. I think I've got a couple of minutes now just to start my submissions. So, looking at the statutory scheme, as we know, we're looking at the Education Act 1996, and this is a consolidating act, as opposed to 1944, the 1944 Act, which was not a consolidating act. And you have authority for that in case of Spires and Warrington, tab 33, MS 533 at 539. The 1944 Act was not a consolidating act.
Yeah.
But the 1996 Act, we know, is a consolidating act.
This is the 1993 Act.
Because it brings in the 1993 Act and other measures which were outstanding elsewhere.
Yep.
The starting point of interpretation is the statutory provision at section 444(1).
Yes.
If a child of compulsory school age who is a registered pupil fails to attend regularly at the school, his parent is guilty of an offence. As we know, for day pupils, there is no statutory definition of attend regularly or regular attendance,
Yep.
as opposed to boarders, and I'll come on and talk about that.
Yeah.
As I say, it's a matter of common sense, I argue, and the ordinary and natural usage of the language that failing to attend regularly cannot mean attending school on every occasion on which the school is open, except for one occasion, or lateness. And I'd like to pick up the Hinchley and Rankin case to make good my proposition that even one lateness would amount to an offence on the council's
Yep.
case.
Well, that's not disputed, is it? No, you don't have to make good the proposition.
Well, then I don't need to
the
make good...
appellant and indeed the intervener would accept.
Well, I don't need
Nod.
I don't need to make good
That
the
was
proposition.
how I understood their case.
Well, I don't need to make good the proposition. But if it's correct that being late on one occasion gives rise to the criminal offence, then we say that is a ludicrous interpretation and construction, and this court should not interpret a statute in a way which gives rise to absurd results, even if there wouldn't necessarily be a penalty notice, and even if there wouldn't necessarily be a prosecution for failure to pay under the penalty notice. But one should not interpret a statute which does lead to the absurd consequence that one late attendance is, on its face, a criminal matter. I've put forward in the... my lord, I see we're after...
At a convenient moment.
That's a convenient moment.
Very well. We'll adjourn now and resume again at 2 o'clock. Court's now adjourned.